Most of you will be watching these videos because you already know that you're looking for care management services, or you're already working with a lawyer to create your estate plan or your trust documents. But sometimes people reach out to us where they think a special needs trust might be right for them, or they've been referred to get a special needs trust, but they're not actively engaged with a lawyer yet, and they're still learning about what a special needs trust is and who it's for. For those folks, and really anyone who wants a refresher, I'm going to do a primer on special needs trusts. I'll also note that Plan of PA can offer educational talks, both in person and online, if you would like me to come speak to a group about this topic. So first, let's define some terms. A trust is a legal document which governs how a sum of money will be managed. The trustee of the trust is a person or organization in charge of managing the trust funds according to the trust document. The grantor is the person setting up the trust, and the beneficiary is the person the trust is meant to support. Special needs trusts exist to allow people to keep assets that are for their benefit and not have those assets count against them when they're trying to qualify for certain programs that have resource limits. Examples of those types of programs include SSI, Medicaid, and the home and community-based waiver programs for long-term care. Special needs trusts have sort of a trade-off where you're allowed to keep that money, but to do so, there is a number of rules for how those funds can be used. Standard aspects of a special needs trust include the following. They're irrevocable, meaning once they go into effect, you can't undo them. Funds can't be given as cash directly to the beneficiary. Funds can't be used to pay for things that your benefits are supposed to cover. The funds in the special needs trust also can only be spent for the benefit of the beneficiary, not for other people. And finally, the trustee has the ultimate decision-making power on how the money is spent and how it is managed and invested. When we talk about special needs trusts, there's two main types. What determines which type is where the money came from. The first type is called a first-party trust. That's a trust where the money is your own money that you're putting into a trust, and the trust is for your benefit. In that situation, you are both the grantor, the person setting up and funding the trust, and the beneficiary, who the trust is meant to support. In first-party trusts, there's more rules and oversight. That's because the state has more interest in what happens to the money. The main reason that the state allows you to keep your own money and also keep your benefits is that you have to engage in a trade-off. The Department of Human Services, which is the state entity that administers Medicaid, is entitled to pay themselves back from your trust money when you die. In other words, if there's any money left in your trust when you pass away, the state will collect that money to pay for medical care it provided to you. And usually the cost of the care is greater than the amount that was left in the trust. So usually that is all the money that was left in the trust. So that means family members are not able to get any of the remaining money in the trust. Because of this arrangement, we often try to ensure that first-party trusts are spent down as much as possible so that the money is spent on the beneficiary and doesn't end up going back to the state. But this is the trade-off that you make to be able to keep those funds for your benefit and also stay on your public assistance programs. The other main type of trust is a third-party trust. That's when someone else, other than the beneficiary, is putting money into the trust. In a third-party trust, it may be a parent or a sibling or an aunt or an uncle who is the grantor setting up and funding the trust for the benefit of a different person who is the beneficiary. Third-party trusts don't have the same level of oversight. The state is not entitled to any of that money when the beneficiary passes away. The grantor decides where the money would go when the beneficiary passes away, and they write instructions in the trust document for what their wishes are for where the money goes when the beneficiary passes. Whether you have a first-party trust or a third-party trust, you have to choose if you want that trust to be a standalone trust or a pooled trust. A standalone trust is a custom trust written custom for you and your situation by a lawyer that you hire. The benefit of a standalone trust is that it can include a lot of custom detail about how the trust can be used, who can help the trustee make decisions, where the trust money goes when the beneficiary passes away, etc. The investment approach for a standalone trust is also tailored to the beneficiary. It can be invested according to the investment preferences, needs, age, etc. Generally speaking, the standalone trust is very customizable. One of the drawbacks is that it can be very expensive to hire a lawyer to write a standalone trust. Another concern is that if it's a first-party trust and the beneficiary is over the age of 65, they won't be able to put money into that trust. You can only put first-party money into a standalone trust before the age of 65. You can't put your own money into a standalone first-party trust once you're over the age 65. Most people will want a standalone trust instead of a pooled trust if they can afford a lawyer and if they are within the age criteria which applies to those first-party trusts only. How is a pooled trust different? The pooled trust is a trust that is already written and already exists, and it has standard language that can't be changed. So, it's not custom. You're only going to be able to join onto an existing trust that is already standardized. The trust document is called the master trust, and the document that allows you to open a sub-account and join that master trust is called the joinder agreement. At Plan of PA, we do administer pooled trusts, so we have a master trust document for a first-party pooled trust and a master trust document for a third-party pooled trust. When you join a pooled trust, we open a sub-account for you. That is your account on the pooled trust. Part of it will be invested with other people's funds, and part of it will be kept liquid to pay for your expenses. In a pooled trust, the funds are pooled for investment purposes. That means that they are in a standardized portfolio with the other funds from other people's sub-accounts. So your investments are not able to be customized for you. But I do want to be really clear that the money in your sub-account can only be spent on you for your benefit while you're alive. It's not going to be spent on any other pooled trust beneficiaries. Additionally, the portion of your money that is invested in the pooled portfolio is tracked by a special software. We know that that's your portion, even though it's invested with the other funds, and we keep track of it so that it is yours alone. Why would you choose a pooled trust over the individualized standalone? Well, a pooled trust is allowed for people who are looking for a first-party trust and who are already over the age of 65. A pooled trust would be the only option for those people to set up a first-party trust. Please note, if you are over age 65 and living in a nursing home, or if you are using a long-term care home and community-based waiver, and you want to set up a first-party pooled trust, we should discuss some details first. While it is allowed for you to join a pooled trust over age 65 as a first party, there can be certain circumstances where the state of PA still may have some impacts on your benefits. So we want to discuss those. At any age, sometimes a pooled trust is desired for other reasons. One reason might be if it's a smaller amount of money. Maybe it's $30,000 and you don't want it to affect your benefits, but you also don't want to spend a big chunk of that money paying for a lawyer to write you a special trust. You might want a lower cost of entry for setting up the trust. With a pooled trust, the cost of entry at Plan of PA is just that initial one-time setup fee, which is a lower fee for the pooled trust than for the standalone trust. The pooled trust is much cheaper to join because you're not hiring a lawyer. You're just signing to join the trust. It is also faster for that reason as well. So if you have a sum of money that you inherited or that came from a settlement and you need to get it situated ASAP before it affects your benefits, a pooled trust is a quick option. Only nonprofits can manage pooled trusts. Something important to be aware of is that if you have a first-party trust and you choose to do a pooled trust instead of a standalone trust, that means any money that's left in your trust when you die can go to the nonprofit that manages that trust instead of going to the state to pay it back for Medicaid expenses. A lot of people like that because that means the money is going to a nonprofit to help other people instead of going to pay back the state. With our pooled trust at Plan of PA, if it's a first-party trust, we will retain 100% of any funds that are remaining when you pass away. If it's a third-party trust, we retain 30% of the funds that are remaining in the trust when the beneficiary passes away. With the third-party pooled trust, the grantor can designate who would get the remaining 70% of the funds when the beneficiary passes away. Keeping remainder funds is standard practice for nonprofits managing pooled trusts. Those retained funds are able to go back towards our mission and helping other people. So, those are the key different types of trusts. First and third, pooled and standalone. With first and third, the difference is how was it funded? With pooled and standalone, the difference is how was it written? If you need more guidance on this, we can refer you to trust lawyers who can answer your questions in more detail. We hope you'll follow us for educational content that may touch on these topics and more. As I said, we are able to provide educational talks to interested groups. Special needs trusts are complicated and don't expect to understand all the ins and outs after a quick video, but the fact that you're thinking about this now and trying to make plans means that you are doing the right things, and give yourself a pat on the back. It is a process that takes time. Please reach out to us if we can help you in terms of next steps or answer any further questions. Thank you.